Good morning. Wednesday, February 18th, 9 a.m. We are continuing our work on a miscellaneous tax bill. Couple flags for folks on it. We've divided the testimony on the first section we're going to take on, which is the fish and wildlife fees, into two blocks. We're going to hear from Michael O'Grady and Rob Kidd today, but then we're going to hear from Fish and Wildlife and the Elcar attorney tomorrow. So try to keep your thoughts together, even though they're one day apart from each other. Sorry, such is the schedule. And we are moving towards having committee till having testimony until 3 o'clock on Friday, including a vote. So let me know sometime today if that's really not going to work for you.
You just tell us what that vote is.
Oh, it's a bill that came from corrections that I haven't looked at yet and I can't tell you anything about.
All I need to know.
I don't even know the bill number. It's about fees. Okay, with that,
Fees for inmates who are leaving incarceration, you're charged a fee in order to get identification.
yes. Okay, with that, Michael, if you want to get us started, taking us through your section, and then we're going to hear from Rob Kidd.
We lost the document, sorry.
You did it.
So this is Mike O'Grady with Legislative Council. I'm going to walk you through a couple of sections in the miscellaneous tax bill related to the authority of the Commissioner of Fish and Wildlife to charge for fees for the use of lands, roads, buildings, or other property within the department's authority. But before I do, I want to give some context, which you probably all know, and how this section evolved. So as you all know, the Constitution provides that all revenue bills start in the House. And you've codified that even further by saying in statute in the fee chapter in Title 32 that all, as a uniform policy on creation of executive and judicial branch fees, that the General Assembly has to approve them. And you have to approve the rate and amount or any adjustment to that fee. And the fee chapter defines fee to include a license, because a license is a revenue producer, just as any permit fee would be. But you can delegate that authority to departments, which you have. In 1977, you delegated to the Department of Forest and Parks for charging fees for using state parks, firewood, etc. And that's evolved a little bit over time. In 2004, you enacted this statute, or this subdivision of the statute in 10 VSA 4132 E, which gave the Commissioner of Fish and Wildlife the authority to charge fees for the use of lands, roads, buildings, etc. And then in 2007, you amended this section again to give the Commissioner authority to charge for the tuition for the Green Mountain Conservation Camps. You can take that authority away. That is your policy decision. If you believe that the department should be proposing these fees in the normal fee process that is within your authority. And that's what section 23 of this miscellaneous tax bill would do. It amends the commissioner's general duties to strike the commissioner's authority to adopt and publish rules in the name of the agency for reasonable fees or charges for the use of land, roads, buildings, etc., and the tuition for the Green Mountain conservation camps. However, there's a provision that says, and the rule that the commissioner has adopted would also be repealed. I do think I want to tweak that reference to the rule. I think I want to include a citation to the Code of Vermont Rules. I was poking around on the department's website yesterday, and
I think the department is actually going to send some clarifying language to maybe leave the camps still with them and have, they
understand.
haven't sent it yet. I think they're going to bring it tomorrow and I'll ask them to look you in.
But for purposes of continuation, transition, however you want to characterize it, they will report back to you on January 15th, 2027 with the recommended fees to be charged for lands, roads, buildings, etc., and for the use and tuition for the Green Mountain conservation camps. That would obviously change if they still retain the tuition authority. And then in the effective dates, you'll see that this repeal doesn't go into effect until 2027. So you get a report back about what the fees should be. There are fees that are in existence now continue until that repeal. So you don't have a period where there's no fee being set.
Anyone have any questions?
So just for clarification, Michael, I brought this up just a month ago. The Rules Committee gave the rule changes for fees for Fish and Wildlife. Wedding venue, camps, other things. Is what we have in here would keep those in play until next
Until
year?
next year, yes. And I do want to note that looking at that rule and looking at what the commissioner proposed for a license to use Fish and Wildlife lands, it does give the commissioner authority to charge for a license, but it gives him or the commissioner the authority to charge between $50,000 and $5,000. And it doesn't say what the license would be for. It just defines what a license is. And
Is that in the rule or in statute?
that's in the rule. Because a license means a written instrument that authorizes a certain activity on department property, but does not vest the licensee with any property rights. That's really broad. And then it's $50 minimum and $10,000 maximum. So that's the range that the commissioner has under that rule to charge for a license, which is very broad and vague.
Representative Hochul.
I think that's one small clarifying question. Has the Department of Fish and Wild, the recommendations will come back in January next year. Have they already set fees for this coming summer?
Yes, yes. And that's the rule that Representative Hickey was referencing.
And then the Elcar attorney is coming in tomorrow in order to answer any questions about how that process went or goes.
If I could,
Yeah.
a clarifying question. So when you're talking about license in there, is what the commissioner proposed, earlier, actually a license? Or is it something different?
I think that's the terminology that you use, conservation license proposal. I would note that I'm not aware of any fish and wildlife license that has been created in rule. You generally do that in statute. There is a long section of law called the license section. For every license that you, generally every license that you authorize, Fish and Wildlife is authorized.
So again, if license is not really the term that should be used, is there another term that commissioner could use that would impose a fee for the usage of the boat docks?
Yeah, yes. That technically I would say is within the commissioner's authority because the access areas are Department of Fish and Wildlife land. I will say that, having worked on that issue in the past, it's not as easy as it sounds. Who carries the license? Where do you carry the license? If you're with a group of campers, does everyone need a license? Is it only for commercial, even though commercial is not allowed to use an access area? Have you now turned everyone into a commercial user by requiring motorized vessels to have a license? I mean, those are all the questions, and there are more that come up. Do you need a decal? Do you need a actual license carried with you like your Fish and Wildlife license? Those are all the common questions that come up with that.
Okay, thank you.
Representative Page.
I'm curious, has Fish and Wildlife ever abused this authority in the past?
I wouldn't say that I know of that. I think you've given them you gave them basically the same authority that the Department of Forests and Parks has for the use of state parks and lands that Forests and Parks control. And to my knowledge, it's been used consistently since then, 2004. And I think I actually drafted this language that gave them. I think Representative Bradigan was the reporter. And
I'll turn back.
so, but I'm not aware, Representative Page, of that.
And is there a way currently, if fees are instituted that perhaps this body doesn't care for, is there a way, do we have the authority to rescind?
Yeah,
Okay, so,
And is that what we're doing here?
that's exactly what you're doing here.
but there isn't anything else that's in statute other than what we're going
That gives the commissioner that fee authority. No, there isn't anything else.
for us to rescind it. There's no way for us to rescind it other than this proposed bill.
I mean, this is the commissioner sets those fees in a rule. The authority that the commissioner has for the rule is this statutory provision in 4132. If you don't want the commissioner to set those fees by rule anymore, you have to rescind this authority so they no longer have that and repeal the rule, which you have the authority to do also, since rules are legislative authority delegated to an administrative agency, but you can repeal that.
Representative Holcomb Brannigan.
No, and there's no way we should when that particular provision that we're repealing was put into.
2004 was the first time the authority to charge fees for use of lands, et cetera. And then 2007 was when the Green Mountain Conservation Tuition was added to it.
Thank you.
Representative Brannigan.
And this clause that we're adding here, or would add if we approve it, takes that authority away,
Yes,
brings it back to us.
it repeals it, and then the default is going to be the fee statute, which requires the General Assembly to approve any fee or revenue generation. And there's a process for the fee. They're supposed to submit it as a fee report, et cetera.
So Well, part two of my question, what do we do then about the current governor's wish not to have a fee report?
Well, you have a report back from the commissioners specifically related to these fees. And you have a repeal of these fees. So if the commissioner doesn't report back with the proposal and you don't enact them, then there would be no fees for next, not this coming summer, for the subsequent summer.
We do have, two years ago, three, at some point recently, we changed the reporting requirements around fee reports to make them much more explicit and specific throughout all of state government, and there's now a process with JFO where they work through those. We are not spending a great deal of time on them because the passage of said fee changes is challenging despite our revenue challenges. Yes. But we do have much better information than we have had in the past. So if for whatever reason they did not bring us this report that they would be required to under statute, we could put back in place appropriate fees. Or we could even just repeal the sunset if we need to, right? If that's what you're concerned about. Yeah, Representative Nissen.
Yeah, using sort of basic generic language, if the choice is to create an exception versus going back to basics, I'd much be in favor of going back to basics. We add exceptions to things from time to time, and we make our lives and Mike's lives kind of complicated because then we have to negotiate around what we said we'll do. And this is kind of generic language, but I think you understand where I'm thinking.
But I think it's a good point because you do not withstand your general fee authority
Right.
and in existing statute in 32 VSA 603. So you did create an exception. And now you're taking that exception away.
Thank you.
Do we know why we created the exception? Pardon?
I
Or shouldn't I ask that question?
You don't want to ask that.
it's from my recollection, it's purely from my recollection, being the person that drafted it, is that the department was looking for the same authority as the Department of Forests and Parks and that ability to kind of be flexible with fees and not have to come to the General Assembly every time that they wanted to change a fee for a use of a camp or a use of a facility at a camp.
And we'll hear from them tomorrow with some sort of splitting the difference on this to some degree with leaving them the flexibility around camp entry fees. Yeah.
I just want to put in a bid for taking away the exception because I think this increases transparency as well. And one of the things that happens when an administration doesn't advocate for appropriate revenues is that certain purposes crowd out other purposes, but we have no ability to see where that's happening. Whereas at least if we're having a consistent, coherent process, people can see what's going on.
Well, I guess I would take exception to that. I think we're creating a bureaucracy. I think we should allow the commissioner to set the fees that he or she wants to. We were briefed on it by him when he made this proposal. And, in some ways, I think we have better things to do.
Would you recommend that for all agencies and all?
Maybe not, but in this case, it seems as though it works well.
And I would agree that and we can talk about this more tomorrow and the next day because we still have more testimony to take on this. But I think it was working well. And I think frankly, the department sort of overstepped the legislative intent of their delegated fee authority. But we have more time and more testimony. Any more questions for Michael? Thank you, Michael.
You're welcome.
We do.
Yeah, the creation of the license.
So I do
Oh, yeah.
recommend a tweak to the citation to the rule. Should I just talk
Yes,
to
please.
Kirby about? Yeah.
Thank you. Kidd, would you like to join us?
Yes.
Thank you.
Thank you very much for accommodating my schedule. Sometimes on mornings I can't get here early enough, and I'm here. So thanks. First off, my name is Rob Kidd. I'm the state director for the Vermont chapter of the Sierra Club. For those of you who don't are familiar with the Sierra Club, we were actually formed in 1892 as an outings club. So all this political stuff that you see me involved with, our bread and butter is connecting people with the outdoors. So this is where when the efficient department announced this possible fee, we got contacted by a bunch of our members to say, what? This is outrageous. And we look at it as an access and accessibility. We encourage people to just get outside and enjoy nature no matter where they are, not looking for signs, not looking for any particular place where they have to pay expensive. Now, the Sierra Club, we lead outings ourselves in Vermont. We have a team of 4 people. I'm one of the certified outings leader just as a convenience factor, but I have 3 volunteers who do that. We have other groups around the state who lead people into different areas. And those type of programs are not really impacted about that. We like actually, even when we do outings, a lot of times conserve lands, I'll make a donation to the location that we're doing. So it doesn't affect our outings programs. As well, we have a national outings program that actually raises money for the Sierra Club that brings people to different parts of the country. And we will have outings leaders from around the country bring them to Vermont. So we do bring them out to different areas and resources as well. But I wanted to kind of flesh on, first off, is our broader campaign, Outdoors for All campaign, wants to see people to be able to access all lands. We worked with the military outdoors program where we even did a training in Lincoln, Vermont back in pre the pandemic, where we trained dozens of outdoor outing leaders who had military experience. And because we figured out it was a really good tool for them to do post their military service and connecting people into the outdoors. So we look at that as there. We also have what called nearby nature, just getting people out to their local community and exploring different trails that they don't even know about. One of the things is I partnered a couple of times recently with the Millstone Trails in Barry Websterville, where we just went a couple snowshoes and people are like, I didn't know this place was here. There's other smaller places that I've done some outings with that are just kind of like, they're in your backyard. I've even led a couple of people from my board on unofficial outings up into Hubbard Park here. There's lots of resources. So we see programs like this infringing on that people's ability to get into those lands. And now I want to be cognizant, yes, the funding revenues are short and they're tight staff. So we're not blanketly opposing any type of fee. We would like, a full process. We encourage the department to look at this and vet every particular funding process. When I first was messaged from my national campaign, Outdoors for All, they said, oh, there's a great program in Kentucky called the Kentucky Wild. Now, and where basically they partner with a lot of private entities, raise money for that to supplement the fish and wildlife access fees. So those who like wild lands, they can actually support and contribute to that, to the different manufacturers of sporting equipment. They can all contribute to that, and it helps elevate the needs for that. So what we would like to see is the department and then even the legislature to do a much more open investigation on this to see what works for Vermont scale, not just adding a fee that prevents people from accessing the land. So basically with that, that's what we would like to see is something more of a process, not just, saying, hey, we got to tax this and add this extra burden onto people. Now, and some people will say, a $50 fee, oh, that's nothing to access this beautiful land. Well, people already own this land. This is the public's land. And with the nature of how much public land is being attacked around the country, we don't want to see it turn into a commodity where people who own it can't use it. So that's why we're requesting this particular land. And then I've always heard people argue with us and say, well, the fish hunters and anglers are the one paying for the department's budget. And yeah, I agree with that because they're extracting a resource. A lot of hikers and people who recreate practice what's known as the no trace principle, where we do not take things out of there. So it's kind of a difference. When you're extracting something, yes, there should be a fee. When they're not extracting anything and you're following rules, you should not be penalized for that. So that's the short story is, and I'd be happy to answer any questions if you need it, but I don't want to take up much more of your time. I don't have a legal analysis. That's Michael's job there to do.
Any questions? Yeah, Representative Bodie.
You said if you're piping and not extracting, and then you said following rules.
I mean, if you're not like, all of a sudden cutting down trees and not digging up dirt, like, my son goes in my backwoods and builds mountain biking trails, that's for our private woods. But if you all of a sudden start going into a public landscape, that'd be a little questionable. We don't want that happening. That's why I said, like, you're following, like, if you're doing things that are not appropriate for the resource area, or you're doing things that are impacting the landscape, yeah, we want that to be regulated.
Thank you. Oh, yeah.
You had mentioned public lands being attacked. Can you give me some examples?
Yeah, so around the nation, a lot of the public lands are being sold off for access to more minerals, access to more logging, even making more commodities. See, some of the national parks are trying to make them more service oriented, more hotels and more industry, instead of just leaving it forever natural. And that's what basically I'm seeing is more of the tax happening nationally.
And I guess as a follow-up, I mean, would you consider some of the things that Vermont has done as far as Act 21's Tier 3 and Act 59 and the Wildlands Bill all being also a public lands being attacked?
I don't see the lands being attacked in those particular areas in Vermont. I see we're trying to balance out the difficult needs, like, we have housing prices. We do. It's not something that we have to ignore. And then there's the Vermont wildlands where, like, I think there's a good conversation that we need to have. As Sierra Club, we actually submitted a letter supporting of that bill, but we should realize that there needs to be a more process of what's designated as a wildland. What's making things open and have a more vibrant public discussion instead of just letting a few of these decisions made within the agency bureaucracy or even the legislative process. I don't know. We'd like to see more vibrant public discussion on this.
Thank you, Rob.
Thanks, Rob. Take care. Oh, yeah.
Just a quick follow-up on Representative Higby? No, yeah, thank you. Higby's comment. If you're looking at a scale of access to public lands in Vermont over, say, the past 20 years, would you say we have more access, less access, or about the same? Put that on the continuum.
What is created from like 20 years ago to now?
That's what's available.
What's available? If you think about just total access to land.
Yeah, I think we're getting at a point that there's more access to land. We're getting it because there's a lot more private lands that are being conserved, but there's a lot of pushback onto like what's posted and what's not. So we have to make sure we're keeping this where it's accessible at all locations, all communities. I forgot to mention there's one program I'm working on nationally, which is not going to come here because it's going to cost a lot of money to do, called Transit to Trails, of how to get people from say somebody lives in Winooski to take a bus to then access the hiking trails. We want to see more diversified landscape conserved, not just in these pockets along the Green Mountain spine. Let's find more places and make it accessible to more people. So I see, yes, we have growing availability, but it's slipping because some lands are being posted and restricted from usage.
It's pressures.
Yeah.
Thanks, Rob.
Thank you. Thank you very much.
Folks, we are going to move from this section of the miscellaneous tax bill to a completely different section of the miscellaneous tax bill, which is related to 529 plans. And so if folks want to pull up the bill for a minute and find the sections, we can refresh our memories as we totally switch tack. Tom Little joins us in the witness chair, but if you want to just sort of move up there slowly so we can pull up the draft. And someone could remind me what section we're talking about, that would be super cool. 12, thank you, Kirby.
Page 11.
I think everyone's done scrolling. The floor is yours, thank you.
Morning, for the record, Tom Little from Vermont Student Assistance Corporation. What I could take some direction from the committee. I could do a brief summary of the history of this program, or I could jump right to the Roth rollover proposal.
A brief history, I think, would be helpful for folks to have some context. I don't think we've taken much testimony on 529s before.
Congress had amended the internal, some people call it the infernal revenue code in the 1990s to create section 529. And you often hear these college savings plans referred to as 529 plans. Vermont, through a House bill in 1999, enacted the Vermont version of it. Under the Internal Revenue Code, there has to be a state sponsor for the program. And in many states, it's the state treasurer's office. And in Vermont, then Treasurer Jim Douglas said, why doesn't VSAC do it? So VSAC has been doing it since its inception. The state income tax credit was added a few years later. It was not in the initial bill. And it provides that for someone who's a Vermont taxpayer who makes a contribution to their plan, they can get a Vermont tax credit when they file their taxes. And there was a lot of discussion and debate when the tax credit was established about how broadly it should be available. And the Internal Revenue Code has a list of permitted uses of the funds in a 529 plan. Vermont piggybacks on that, but has a separate list, a narrower list of uses for withdrawals that are compatible with the Vermont tax credit. So another way of saying that is that there are some uses that are permitted under the Internal Revenue Code that would result, if used in Vermont, a conflict with the state income tax credit. And so that if you used, for example, under the Internal Revenue Code, you can use a withdrawal for K through 12 education. If you, K through 12. If you did that with your Vermont plan and you were a Vermont taxpayer and you had previously taken advantage of the income tax credit, that would be inconsistent with that section of the Vermont tax code 5825A. Yeah. And you would be subject to a penalty and interest for doing that. Historically, this committee and with VSAC's support has kept the focus of the tax credit pretty narrow. Currently, if you use your plan assets for post-secondary expenses, there's a definition of what that is. Registered apprenticeships, I think that was added relatively recently. The death or disability of the beneficiary of the account, or student loan repayment, which is a permitted use under the Internal Revenue Code with a $10,000 cap over the per beneficiary. So it's not $10,000 of student loan repayment per year. It's over the lifetime of that particular beneficiaries. The Internal Revenue Code was amended a few years ago to also add rollovers to a Roth IRA account, provided that your 529 plan account had been in existence for at least 15 years. With presumably an effort to avoid people opening a 529 account, putting money into it, getting some tax benefits, and then rolling it over the next year into a Roth IRA. So you have to wait 15 years. The draft of section 12 will put that at 20 years. So what VSAC is interested to know more about, I'm using the term profile for the time being, of who it might be who has opened a Vermont 529 plan account, has named a beneficiary, has had the account open for 15 or 20 years, and has no other permitted use for the funds anymore. Let's suppose the student, the beneficiary graduated from college and they didn't need all of the money in the account, or they didn't need any of the money in the account. Maybe they had other resources. They had scholarships, work study, and so forth. Did this owner of the account not have any other children? You can transfer beneficiary status from one beneficiary to another. Are there grandchildren that might be coming along the way that could be made the new beneficiary? Is the student who didn't use it all likely to go to grad school, which would make it eligible for use? And again, there's the student loan debt component. We can do some research to see if there is available data that shows what profile, what types of scenarios are out there for rollovers into Roth IRAs, to see if that's a significant component in Vermont. It also may make a difference as to how much money the account owner has in the account. If the account owner has $4,700 in the account and they've used the credit once and they got $250 tax credit, the consequence of the penalty for the $250 credit is one thing. If the account has $60,000 in it and they use the credit 7 times, then you're talking, if it's husband and wife scenario, it would be $500 per year. Then that's a much more significant amount and subject to the penalty. And so those are some other things we'd like the committee to ask about if the committee wants to pursue this. And I can also, if the committee's interested, I can send, we sort of have an annual report that we do about how the plan is doing, what the balances are, how many contributions were made in the prior year, how many withdrawals were taken, and so forth. So, Madam Chair, I will stop there and be happy to answer questions or.
Representative Brannigan and then Representative Woody, do you still have a question?
Can I just suggest that you send us maybe one copy of that report and we can share it? But
Yeah.
I think it would be interesting to read.
Yeah.
Thank you.
Yes. Representative Woody, did you have a question?
Thank you. Yes. Does it help the state of Vermont to have a plan that is open in Vermont?
Well, if somebody opens a Vermont plan under VSAC sponsorship, and they use the tax credit, I mean, that is reducing the revenues to the state of Vermont to the extent that they get the tax credit. And the incentive is that prompts them to save more and help make it easier for their child or grandchild to pursue post-secondary education. But I'm not sure that answers the question.
No,
Okay.
I'm just, if, if, whatever the restrictions are, or whatever the credits are, if someone who's opening a 529 doesn't like what Vermont has to offer, they could go and invest to another state.
Yes.
Right?
Yeah, there's,
So that's why I'm asking, does it help Vermont to have these 529 plans? They're established in Vermont.
Right. There are lots of other 529 plans, and many of them are the one that we have in Vermont is known as a direct sold plan, which means the state itself and through BSAC issues the plan, makes the plan available. In many states, it's a broker sold plan where there's a large financial institution that has the plan, and you go to someone who works for Wells Fargo, for example, if that's the plan administrator in your state, and you have a relationship with them. You may already have a relationship with them, and you have to go that way to buy, to set up a plan. Some states have both. I know that I think New Hampshire has a pretty substantial plan. So you, as a Vermonter, could say, I already have a relationship with Wells Fargo. They have a plan that's cited in Illinois. For example, I'm just going to go with my financial advisor at Wells Fargo and up there, and you forego the tax credit. And I'm sure, I don't know that we are able to track how many Vermont residents are doing that. It's probably those who have a long time stable relationship with a stockbroker. So we think that we competitively, this is a competitive product in Vermont, and I think we have really good customer service and that we're available to, respond to questions or concerns. We had we farm out the record keeping and the investment management, but we also back them up with customer service and Winooski. I mean, the choice was made in 1999 that it would be better for Vermonters to have their own direct sold plan that was from a nonprofit basis and not a large financial institution. I'd like to think that's better, but.
I heard that the organization that's managing the 529 plan is the same organization that's managing Vermont Saves Roth IRA. Is that true?
Correct.
Does that make it easier for anything?
Well, we've just, the BSAC just changed over its vendor last fall to Vestwell. And they are, the treasurer's office has contracted with them to do that other plan. We're hoping that we will see some good harmonics there, and that we maybe do some cross, not marketing, but outreach to some customers may need both.
It's sort of too soon to tell.
Yeah, too soon.
Any other questions?
Just one, I think, Tom, from what you were saying is that you really want to know to how many people this would apply with their experience.
And how compelling are some of those scenarios if you can construct one where a parent or parents have one child and the child had an athletic scholarship and had a full boat and they have a bunch of money sitting in this plan and there's nobody else on the horizon. They don't want to wait until maybe they have grandchildren. Or they don't have nieces or nephews and they don't want to wait to see if the child may go to graduate school. There's no student debt. And so you can sort of construct a hypothetical that thinks, wow, that's really compelling. They shouldn't have to pay the penalty. But it'd be interesting to know what the penalty would be in that case. How substantial a financial penalty or hit would that be? And So what we generally like someone to do in that is to contact us and say, make sure they understand that there are these other options for using the fund that they may not know about. Yeah.
If we can't get an answer to that question, what would you advise we do?
Wait until you get an answer.
Okay, cool, thank you. I love that answer. Thank you very much for your time.
Okay.
This.
You're welcome. Good luck. I did send you and George Anderson a drafting suggestion. If you do go with it, I just think it would flow better a little bit.
Thank you.
Good luck.
Wait, sorry, we have Representative,
Sorry.
late breaking question.
So what do you think the pros are having a more restrictive use? Than the IRS does?
I think it focuses the plan better on the original, I think, mission or goals of it was to try to focus on families that may not otherwise be saving a lot. They may not have thought about saving, and this is an incentive to do that. And it seems to be, I mean, we just reached 700. If you see that in the report, $700 million in planned assets. Nobody would have, I mean, it blows our mind that is what we reached. A lot of that goes out every year. So it goes up and down and we get new contributions. And there are now ways to do it through a payroll. Some employers, including the state, have a payroll deduction option. So it's relatively easy if you have the resources to save a little bit. But if I have more on that, Representative Odie, I'll get back to you on that. Okay. You're welcome.
Laura? Hello,
Ta-da!
thank you for joining us.
Thank you for having me. Can I jump in?
Yes, please. But first, I want to make sure that we all know what section we're talking about with you.
For the record, I'm Maura Collins, the Executive Director of the Vermont Housing Finance Agency, and I'm looking at section 19 on page 17 of draft
you.
1.6.
Give us one brief moment to find it.
Of course.
Page number.
Page 17, it's section 19, so it's halfway down the page.
Yeah, thank you.
Okay, I think we're good. Thank you.
Great. I'm here to say thank you. Thank you for including section 19. You remember that maybe 2 weeks ago, I was in your committee talking about VHFA's very successful down payment assistance program, helping over 2,100 Vermont renters become permanent residents when they became homeowners. And the value of this program is that they've accumulated approximately $15 of wealth for every dollar that the state has loaned them interest-free. And so I take it that that testimony was compelling because I see this language in here, which is what VHFA requested, which was if we could have the ability to continue selling these tax credits for the next 5 years. Previously, as you can see on line 16, that this program had sunset, but the repayments coming back to VHFA for us to re-loan out has dropped off as interest rates have gone higher. We've seen fewer folks refinancing their mortgages. So we did ask for an increase up to $350,000 of selling these 5-year tax credits. And so I'm here to endorse the language in section 19. But there is a memo on your website that I sent in today where I'm not a lawyer, I'm a housing finance person, but I'm a little worried that the way it's drafted now, someone could misunderstand and think that we had the authority to go up to 350,000 for FY 2020 through 2026, which was not the case. We only could have sold 250,000 those years. So I'm wondering to the lawyers if instead we should have a third subsection there that just leaves subsection 2 alone and doesn't make any edits, but instead adds identical language as a number 3 that just says in fiscal years 2027 through 2031 that we can sell 350,000 in total first year credits. And it would be the same language as section 2 that has been edited, but it would just be clear that the additional amount of going up to 350,000 only applies to fiscal years 27 through 31.
Laura, I'm gonna ask you and Kirby Keaton to follow up offline with each other about any edits, and then Kirby can come back to us on what makes sense so that we're not all hanging out here wordsmithing together.
Yep.
Thank you. And
All I had to say about this section, unless there's questions about it.
something better than a witness that just coming in to say thank you. Anyone have any thoughts, questions for Maura? Thanks for popping in with us. Appreciate your time.
Thank you very much.
Thanks. We're really making good time today. Jeff, do you want to join us? Thanks. I call you Jeff in my head. It says Jeffrey on the piece of paper. I don't know what you prefer. I'm so sorry.
Jeff is fine.
That's great.
So, my name is Jeff Dooley. I am the taxpayer advocate for the Vermont Department of Taxes. And
On behalf of all my constituents that I send to you, thank you very much.
you're welcome. So this position was created in 2001 and later codified in statute. I won't read the statute for you, but basically, the way I see it, that I fulfill 2 roles in the Department of Taxes. One, I'm the voice of the taxpayer in all discussions when they're making policy decisions or in directors' meetings. If they're talking about actions that the department is going to do going forward, I try to represent the taxpayer in those discussions. And then also on a more micro level, when a taxpayer finds themselves either having gone off the rails and dealing with the department and need to be put back on track, I assist them with that. And there's also a program in statute called extraordinary relief, where the letter of the law applies to a taxpayer in a way that's unfair, unforeseen, or creates a financial hardship. They can come to me. I can look into their case, summarize it for the commissioner, present it to him with my recommendation, and then he can choose to use his power to either approve or deny that request. In the past year, I've gotten approximately 70 extraordinary relief requests. We've been able to grant relief in 63 of those cases. The vast majority of those cases are property tax credit cases where someone has missed the deadline or filled out the form incorrectly. And I'm sure, as you're all aware, the requirements around the property tax credit are very strict and can be harsh. And generally speaking, it's dealing with lower income individuals who may not be as sophisticated as other taxpayers and don't have the means to hire a preparer to help them with those issues. So that's the individuals who tend to come across my desk. So what new initiatives have we done in the past year? One, and this may be a little bit in the weeds, but I'm excited about it, is we added a taxpayer advocate case to our VTAX system, which is our main tracking system for taxes at the department. And prior to February of last year, we were just tracking all the cases that came across the taxpayer desk on a spreadsheet in Excel, which was not ideal. Things fell between the cracks or were not updated as well. So now there's a case in our system that can show when the case was created, what stage it's in, how long it's been in that stage. And so it's really helps me service the taxpayers that come across my desk. And it's going to, I think, in the long term, provide a lot more robust data that I can provide to this committee coming forward. So I think that it's going to be a win-win for myself, taxpayers, and for the committee. So I'm excited about that. The other big administrative initiative that we've done in the recent years is we've fully staffed our communications team, which is a big win for the department. And one of the things that they've been focusing on is improved access, ADA compliancy, and also language access. So we're able to now translate our forms into the 14 most common languages that are spoken in Vermont and provide translation and interpreter services if someone needs that to deal with the department, which I think in the long run will really improve our ability to communicate with Vermonters, especially those who don't speak English as their first language. So we're proud of those two initiatives. In terms of statutory proposals, I think this was already added to the miscellaneous tax bill, which I'm appreciative of. Is there's an issue in Vermont with the well, there's many issues in Vermont with the property tax credit, but one of them happens to be yes. It doesn't really deal with divorce in a way that the real world deals with the divorce. It basically treats divorce as if you file for divorce on a Friday and by Wednesday of next week, the divorce has been finalized and you can go on with your life. Anyone who's gone through a divorce or knows anyone who's gone through a divorce knows that's not really how the system works. So the way the law currently works is if you're subject to a divorce proceeding, and your spouse has moved out of the house and you file property tax credit, you not only have to include your spouse's income in household income, which therefore lowers your property tax credit, even though 9 times out of 10, the spouse isn't contributing to the household expenses, but also because that spouse is not physically living in the house, you have to claim 50% ownership on the property tax credit form, which reduces your property tax credit even further. So someone who, if they were just including their income in the household income and were claiming 100%, might be getting a $2,500 tax credit. But because they have to include their spouse's income and they have to claim 50% tax credit, might only be getting a $300 or a $500 tax credit, which doesn't reflect the reality of what their expenses are and their ability to pay the property tax credit. So what this statutory proposal does is it still includes the part where you have to include your spouse's income in your household income. And that just basically avoids people gaming the system. But it doesn't require the person to claim 50% ownership. They can claim 100% ownership if they and their spouse own their property together. So that's what the statutory proposal does, and I appreciate that it was included in the miscellaneous tax bill, and I hope that it gets passed. One other issue that has come across my desk in recent weeks, and I...
Before you go to a new issue, does anyone have any
Sure.
questions about that issue that's in miscellaneous tax?
Yeah, I have a couple of questions. I think we talked about this last year. And I'm just wondering how often this comes up when you're dealings with taxpayers. Property tax credits is the majority of the issues. Is this related to that specific issue about divorce?
Yes, I would say it probably comes up 2 or 3 times a year across my desk, which, uh, across the population of Vermont is not a huge number, but then whenever anything comes across my desk, I wonder how many people are affected by this that don't elevate the issue just because that's what the tax form says, or that's what their preparer says, or that's what someone says. So I always,
House, there are 10 and a half.
yeah, I see my inbox as kind of the canary in the coal mine where, if I see a couple issues, there's definitely more out there that I'm not seeing.
Why didn't we move on this last year? I remember.
I can't speak to that.
I don't remember. Did we talk about it last year?
We did.
Oh, I don't know. Maybe it just got lost in the mix of the year where many things got lost in the mix of the year. Because so many other things were still happening. Yes. Anyone else? Okay, the other issue, sorry.
Yeah, one issue, and I think you may, Representative Corbin has spoken to this taxpayer as well, where there's an issue where if there is mistake made at the town level where where someone's property is overappraised, or a building on their property is overappraised or something along those lines, where the money goes to the education fund straight from the town, and the person can apply for an abatement at the town level, and they'll get the municipal money back, but there's no effective mechanism to get the education tax that was overpaid back to the taxpayer. And I know that,
There is a mechanism, the town just needs to cover it.
well, and most towns are not
Yes,
willing to
yes.
cover it, which is what creates the problem. So I know that this committee and the legislature at whole is doing a lot when it comes to property taxes, and this may not be an area that you want to laser focus on, but it is an area where it does create some inequities where someone may end up not being able to get back education property tax that they've overpaid and probably are rightly entitled to a refund on. So I did say that I would bring that up. And so
So the specific scenario, to add more color to it for people, is someone had a building on their property long, long ago, perhaps even before they owned the property, that burned down or was torn down, maybe before they owned the property. They didn't, the folks who were valuing the property thought that building was still there, and they had been paying property taxes for years based on this extra building on their property, and then caught it. And so I think there's, like, as we think about this conversation, I think there's a question of, do we do something about it in the context of the new regional assessment districts, when we'll have a very different sort of state level ownership management oversight and standards around assessment than we do under current law? Because I think one of the pieces that we really, like, one of the core interesting pieces of the regional assessment district conversation is, where does sort of the work, the authority, the oversight, and the financial incentives, do they all sit in the same place, right? And I think under the new regional assessment districts, having the state issue the refund has policy consistency. I think under the existing assessment regime, it's the municipality that should be responsible for the full sum, if we're sort of keeping money and accountability in the same place. That doesn't mean that that ever makes the taxpayer whole, which is a sort of a third piece of the question that we need to answer. But that's just sort of the back and forth that I have shared with this person who's been writing to both me and Jeff,
yeah.
who just wants their problem solved and does not care about, all the hypotheses. Reasonably so. Yes.
So, and I will say just talking about frustrations that that taxpayers have had that I've dealt with in the past year. One that has been consistent. And I don't think there's anything that this committee can do about it, but I will at least flag it, is when someone does file their homestead declaration late, the town has the option to assess a late file penalty on that individual. And many towns I've noticed have told that taxpayer that the state tells them they must charge that penalty, which is not accurate. And then the person comes to me and says, can you help me get rid of this penalty? And then I send them back to the town, and then they feel like they're getting stuck in this feedback loop where everyone's pointing a finger at each other. So I would just like it on the record that it is the town's discretion to charge penalties on late filed homesteads.
And so you don't think we need to change any statute? It's just that we should all say on the record that it is the town's
Yes, I think
authority
that,
to charge that fee.
yes, and maybe the town, if the League of Cities and Towns can get that message.
I believe they're
clear.
going to testify tomorrow on, yes, so if anyone wants to bring it up with them.
And then the last thing, just is something that, I've noticed, because I identify industry or class issues, where people have struggled to deal with the department, is there have been a lot of, movement in the local option tax area in, recent years. And I know that there's a lot of, take up a lot of administrative effort when we institute any of these local option taxes, and it does cause a decent amount of confusion among businesses that are in those towns or adjacent to those towns. Who charges the tax, when they charge the tax, and we have to do a lot of outreach, and which we try to do as proactively as possible to let people know when they're in charge of this. But then we also have to do a lot where this business isn't charging it when they're supposed to, this business is charging it when they're not supposed to, and then we have to do a lot of one-on-one interaction with a lot of businesses in order to every time that we stand up one of these local option taxes, in order to get it working so that everyone's on the same page.
I'll say one of my primary concern when we changed the local option tax authority last year was that we wouldn't be able to just look the town manager in the eye when they came in and say, this is more complicated than you think it is, and it's not the tax department's fault.
Yeah.
And like, I don't know if we could like record a video that gets sent to every town that wants to do this, because it's really like it's a significant challenge, and there's lots of blame to go around that I don't think deserves to land necessarily anywhere. Do you have any fixes that you might suggest for it, or it's just an ongoing issue?
Other than not instituting new ones, no.
Okay. So I think we're just gonna have more and more as the state doesn't raise revenue. I think municipalities are doing it more and more on their own. So I don't see a choice.
Yeah, and as in that's I'm sure one of those communities where in Vermont, zip codes are not necessarily as clean as they are in other states, and so that also creates an additional.
If a business really wants to comply, they have to invest in software to enable them to do it, which adds another burden.
Yes, yeah,
For flowers throughout Chittenden County.
yeah,
This town has a local options tax, how much it is.
yeah. There are CSPs, which are the acronym. I'm failing to remember exact certified something, but who provide that service. But yeah, that's a cost. And then in addition, we've even ran into issues where they haven't been doing it correctly for a couple of months, and we had to contact them and get them on the right page. So it is an issue.
Another big picture observation based on what you just said. I think I heard you say it's the state doesn't raise the money to fund things that are needed across the state. Municipalities are raising the money themselves. Now, this is what ended up leading to the Brigham decision, which is where where, if you didn't have very much grand list, you couldn't easily fund your students to be educated. And this not raising enough money on the state level puts low grand lists towns at a tremendous disadvantage. Vis-a-vis have a greater grand list where it's easier to raise. With a smaller tax rate, more money
For municipal services.
for municipal services,
Absolutely.
or for things that fall upon your town.
Mhm.
Like a garage.
Yeah.
House your snow plows, whatever. So I just wanted to say that.
We actually asked for, a lot of states handle it that problem very differently than we do, and JFO did a report for us a couple of years ago, fairly recently, about how sort of municipal funding and revenue sharing and things like that work state to state, and it was a great report. I think Ted was the main author on it, but I can unearth it and send it around. It's very helpful. Yeah, agreed. Back to you.
That's about all I have. If anyone has any questions about what I've testified on or my role in general, I'm willing to answer them.
Thank you so much. Oh, yeah, Representative Brenningham, go ahead.
But when do you deal with current use issues?
Rarely. Yeah.
One right now with the constituent, so do you want me to?
You can send them to me. I probably will loop in someone from our PBR unit because I know just about enough about current use to be dangerous. I'm definitely not an expert.
Thank you so much for your time.
Great, thank you very much.
Appreciate it. Rebecca, you're next up and you're last on the list.
Good morning.
Right in.
And some of the folks we're hearing from today, this might be the only time they testify on miscellaneous tax. When we have sort of a final bill, we'll have the department in one more time to do sort of a, can we administer all of these random things you people put in here? Kind of conversation. Floor's yours.
Great. Well, Rebecca Samroff, Deputy Commissioner, Department of Taxes for the record. Can't wait for that testimony just described. Yeah, and I'm actually mostly just here to say thank you as well and catch any questions that have come up in the interim. Since I was here last, the bill draft now includes a state tax filing threshold language that we proposed and some chip equalization language, among other things. I was also excited to see the taxpayer advocates proposal in here. It's something that the department as a whole thinks is a great idea as well. So it's handy alignment. There is one more proposal that we did put forward that I'm just going to make another plug for here, which is repealing some obsolete statute around tax delinquency proceedings that suggests that PBR oversees this function. This is actually currently not a PBR function, and a more recent statute has tax sales managed entirely at the municipal level. But it seems like especially this year, but kind of ongoing, we get tagged or asked to weigh in on these municipal proceedings, which is not currently in our jurisdiction. There's a couple areas of statute that we'd love to get repealed that were originally enacted in 1919, last amended comprehensively in 1959, and have been overcome by other statutes. So there's action in the State House this year that we keep getting asked to come in on to testify. I don't think I can blame this old statute for that, but just it just feels great to be able to clean up the traces of areas of administration that we're not involved in, just to kind of help unified understanding of who does what in this great state. So we did send that language to Kirby early in the session, and happy to again if folks have any appetite to revisit that.
I was trying to figure out how it sort of fits in with the expanding authority we're giving to PBR with the regional assessment districts, and if it makes sense to have that in the regional assessment bill language. because it's sort of like we're sort of moving toward the center between those two things to some degree. So
I'm open to vehicles.
Yeah.
Sure, yeah.
Yeah.
Yeah, that would be great.
Okay. Yeah.
Yeah, great, awesome. So that's wonderful. Would love to keep discussing that.
Yeah, just curious, is that more in the realm of government operations as well?
Well, my understanding it's like, it's purely a municipal function now, like the tax sale process and all aspects of that. It's nothing, recently we've been asked for data on tax sales a lot, which is, because we're not involved, we don't have any, requirement of municipalities to be reporting those proceedings or outcomes to us. So, it's just, one example. But it's it's not something I have expertise in. Nor does PBR these days.
Would be cool if someone knew about tax sales.
Municipality knows about tax sales. Or maybe, yeah.
If someone was tracking it at statewide level. Could just be like a Google form. I don't know. Okay, continue on.
I cannot deny the coolness of access to data as I wouldn't say recovering data nerd, but former data nerd.
Just before you go on, are you thinking on the property transfer tax returns, is there any indication from those that it's a tax sale?
I'm not sure about that. I'll take it back to you about that. I would assume not. I don't think those are done through property transfer. I'll get back to the committee on this. But that's not my understanding of how our property transfer return would work. On the 529 issue, that was a really great testimony from Mr. Little. I just wanted to, as we heard from him, there are certain uses of the 529 funds that are federally allowable but trigger tax credit recapture here in Vermont. So this would, effectively move that IRA rollover, which is federally allowable, from the recapture bucket into, Vermont's allowable bucket. The income tax treatment for these funds does flow through to Vermont. So we're totally aligned on that. We don't have like any major concerns with that policy choice to pursue that or not. However, would strongly suggest some edits to the language as drafted. When I chatted with Mr. Little about this, we were actually exactly on the same page, and the language that he provided to Sorsha matched our recommendations. It was just moving the new statute in rather than putting it in its own subdivision, tucking it in with the rest of these rest of these allowable uses. The one further edit I would suggest is that the required holding period for an account to make it eligible for rollover for an IRA is 15 years at the federal level, and this language suggests 20 years for the Vermont specific one, and that's just like another example of where, a minor deviation from the federal rules could add a lot of confusion to, a CPA who's trying to administer this. And
about that, like, that totally makes sense to me that you want to align, but 15 years, like, I don't understand the Fed's choice. And I know that there are a lot of things about federal choices that I don't understand, but in this particular context, at 15, like if you start an account when a child is born, when they're 15, you have no idea if they're going to need it or not, right? And so like in all of the intent that I've heard around allowing the rollover, it's that the account's been sitting there and it's clear that it's not going to be used for educational purposes. And I don't understand how at 15 years you could possibly know that or not. And that's why the different numbers. Do you have?
Yeah, well, I can't speculate for the feds, but it could be that, and I don't actually know about this. I have not opened an account for my children.
Oh, Becca.
I know, I'm really not on top of my personal taxes. I will be by the deadline, to be clear. But I imagine that like I could decide to do this when they are 15, when they're 10, like decide that this is something I finally have the mental capacity to be planful about, so I guess like there's, we are presuming that one would start it when they were born opposed to just like any time when they're a kid, by questioning that 15 years, I guess they could start when they were 5 or 10 or something.
I mean, all the advice heard was that there's actually like no point in starting one once your kid is like 12.
So
Nice.
this time,
I didn't follow it together.
the 15 or 20 years, that language is about the roll.
It's about how long you have to have, the account active to be eligible federally to roll it over to an IRA.
It's not about accessing it if you started when the kid was 5, wait 15 years and 20, they're in their second year of college. To access it for that, yeah.
Depending on the timing of their decision.
That doesn't affect using it for its intended purpose.
Right, oh, yes, right, only for rolling it over, yeah. And the federal law, I was just actually looking at this last night to get more familiar, they also have, they have an exception where you can't roll over the most recent 5 years before your, election to roll it over, which I thought was interesting. I didn't initially realize that. I guess that's supposed to be some disincentive to just make a quick decision, but yeah. This is no policy darling of ours. It would just be awesome if you did want to incorporate this, that we match the federal timeline, or not do it all, speaking purely from like administrative perspective. It's just, if it's going to be, I feel like it's going to put a lot of onus on, like a CPA might not know that Vermont's recapture is more stringent than the federal law, which really, just adds another hurdle to voluntary compliance. And then when it comes to, the type of compliance that we have to proactively track down ourselves, like this is a tricky one. It's pretty labor intensive with the high level data we currently get from VSAC, which just pretty much covers like all withdrawals, not a lot of granularity. But what I will say is that this committee discussion, inspired a nice conversation between Tom and I, and we're planning to sit down in the off season with VSAC's new contractor and just see what is available data wise, maybe refresh the data sharing that we have to, see if we can, either tighten up our process or maybe even come back for in the new biennium with some miscellaneous tax bill recommendations to tighten up the language to really match enforcement possibilities with the kind of data that VSAC gets.
Great. So during that, I would love to take this 529 section out of the bill and do it next year.
Done.
Great.
Sounds great.
Okay, cool.
Yes.
Okay. Look, we made such a great decision there, folks.
Yeah.
I'm trying not to do something. Okay.
And I think
Rebecca.
Yeah, so I know otherwise, those are kind of the things I wanted to proactively bring up, and otherwise I'm happy to answer any questions that folks have to date on other items, or come back all ready to put a bow on it.
Any other questions? Rebecca, you thought that there was a question about
Yeah.
section. I
Section,
don't remember.
yeah, so section 7 of the bill, and I have to pull it up myself too. This is admittedly more of a Jill thing, but I can be a little bit of a Jill thing sometimes. Section 7, I'm having trouble pulling up right now. This is about the transition of communications property from the former like telephone tax types into the property tax rules. The miscellaneous tax bill in section 7 asks for some kind of like enforcement tools for getting our inventories back from communication companies, like telephone, cable, cell towers, things like that. This is language that it was lifted from authority that municipalities have to get these inventories. My understanding is this, like we send like kind of a workbook, like what is all of your property and where is it? And they send it back. And I think the language asks for the ability to levy a $100 fee per violation.
I think I was one of the questions.
Oh, great, perfect. Jog your memory.
That seems like a really tiny fee to create any behavior change to a large corporation. Is it like per property, per day, per whatever?
Our understanding is that it's per municipality. So like, the utility would, or, the company would have a workbook, and for, kind of like to mirror what the municipalities had the ability to do before, we would, any inventory that's missing from a town would be subject to a $100 fee per violation. But I do just want to say that we don't anticipate having to do this at all. It's a pretty tight industry, and they've been very the department and this industry has been very, engaged just over the last couple of years of making this transition. Those inventories were already sent out and we expect to have them back on March 31st. The department's already answering questions about them. There's no, like early signals that we're going to have to, be wrestling these out of companies.
Thanks.
I thought of something completely unrelated.
Great.
So there
See how I do.
Anyone have anything related to what we were just talking about? Great, Representative Wozniak.
Last time we talked about this bill, I was just wondering about the moving the grand list date to January 1, and that's not effective in this draft until 2031.
Mhm.
And I think there's some merit to like aligning it with the RADs and stuff, but it seems like something that we could do quicker. So just curious as to your thoughts on that, or if that's a Jill thought something that's fair.
Yeah, well, I think, I think there is some flexibility there, like as to what future year we make this effective. We definitely want to give folks like some runway and heads up that it's happening. I think like the one policy that we've been discussing in the RAD context of the regionalizing appeals, that's really where this is gonna like be carrying a lot of water. Because for a contractor to be able to, just like manage the increased appeal volume from the contractor and the appeals board, from these, a new regionalized process, I think it'd be really important to have that longer appeals window now between January and when the grand list has to be lodged instead of April and when the grand list has to be lodged. So I think that's kind of like the key timing to hit, make sure it's effective in that year or ahead of that year. And beyond that, I'm not, or like, it shouldn't be next year. And it shouldn't be after that. And I think that there could potentially be some flexibility, but I think aligning the timing of those two things would make a lot of sense.
On another totally different subject, the land use change tax, you guys are okay with it? The language that's in here?
Yes, although I guess I understood that this was the language that we had proposed and maybe it's not. Okay, if it is, then absolutely, we really. Yeah, no, thank you.
Yeah, we haven't changed it at all for you. Okay.
Yeah, I'm really happy where that landed. Seemed like a logical administrative solution instead of like high-tech mathy solution, which we've been cutting around in the last couple of sessions. Very obvious in hindsight.
Rosanna, were you talking about the timeline, basically?
Yeah. Okay. Yeah, it's all about the timeline.
Okay, thanks.
Thank you, Rebecca, and I'll see you soon for something else. Or maybe this, who knows?
Thanks.
Great.
We're waiting, the grazing rights, we're waiting to hear. Representative Kimball just asked me about the grazing rights language. We're waiting to hear back from Ag and Natural Resources about that language.
Great.
So that they can define all the things that need defining there. Okay, switching gears entirely, team. H567, which is the unclaimed property bill we looked at yesterday. I didn't hear from anyone that they needed any more testimony. Do you want to take a break before we do it? Cool. I want to take a break too. So we're going to be back here at 10:45.